Welcome back. The Biden administration has been barred from working with social media companies in a case that two Republican attorneys general call a clear breach of the First Amendment. A judge came down with the ruling this week. Amid concerns, the White House encouraged removal of what it considered to be misinformation over things like COVID-19 and election security. Let's talk about it with Jessica Malugin. She's the director of the Center of Innovation and Technology. Flip that around. Technology and Innovation at the Competitive Enterprise Institute. She's up late with me tonight on the Final Five. I think the meaning would have been the same, but clearly I want to make sure I have the title right. Good to see you, Jessica. Thanks for joining us.
Thank you. It's a pleasure to be here.
Let's talk about this ruling here. So this all came down to something that a judge called dystopian, where you had the administration working with Facebook and Twitter and these companies saying, we don't want you to put out what we consider to be misinformation over COVID-19 during the pandemic or maybe election security.
Yeah, so what you had is two state attorney generals who sued the Biden administration for what they believed was undue pressure on these social media companies. And the government can ask these companies, and as a journalist, you know, sometimes journalists and other organizations are in touch with the government, information is exchanged, but when a line is crossed, when the government is demanding, threatening, explicitly forcing these companies to take down certain content, and that's what we saw when the case went into discovery, all the exchanges between officials in the Biden administration and platforms like Facebook, YouTube, Twitter. We saw what was happening, and on the 4th of July, the judge came out and said, absolutely not, this stops here, and here's a list of things you're not allowed to do if you are in the government. You're not allowed to contact these social media companies and demand that this or that is taken down. And he also included a list of things that were permissible for them still to do. And that's where the ruling gets a little complicated, because it's a kind of a subjective question. One person's misinformation is the other person's truth-seeking, right? Yeah. So I think that this is the beginning of what's going to be a longer conversation about how we feel like the government can and can't influence these platforms.
Do we know in terms of like what kind of punishment or what kind of ultimatums the government gave these companies, or is that still sort of tied up?
Well, we see from those exchanges that they kind of started, a lot of them as polite requests, and there was actually a bit more pushback from the tech companies than I had realized there was. But eventually, the government was pretty explicit about saying, you know, what happens to your Section 230 liability protections if you don't cooperate? Maybe there's antitrust investigation consequences if you don't cooperate. So that's where the judge found that it went too far.
Is there a bigger conversation to have when it comes to regulation? I mean, you mentioned Section 230, obviously something we've talked about on this show. I know I've talked about it with some of your colleagues in the past here. I mean, obviously this is playing out, but what else can be done to keep this from happening, regardless of whether you have a Democrat or a Republican in the White House? Yeah,
I think that you make a great point, because people of any political stripe should be concerned about when the government steps over the line and starts violating our First Amendment rights as speakers. I mean, and that's what's great about these platforms, right? Never before have so many Americans had a chance to speak for themselves. We want to preserve that. But as much as all of these platforms are ubiquitous in our lives, it really is true that they're a relatively new development, and there hasn't been a lot of case law on this, and there hasn't been legislation on this. And like I said, this is the beginning of what's going to be a longer conversation about where do we draw that line about what's reasonable and responsible for the government to communicate to these companies and what's coercive pressure and a violation of the First Amendment. So I think this is the start of us sorting through those questions, and it's not, there are no easy answers. This is subjective stuff, so we're just going to have to see how much progress we can make.
There was a comparison brought up last night when we talked about this, and I think I'm getting a little more perspective from you on this now, but the idea was, look, back in the 80s, we had Nancy Reagan's Just Say No, and you had the government working with the TV networks at the time, which obviously had this massive reach they don't have anymore, saying, we want you to put out these anti-drug messages. We want you to be, we want you to work with us in the war on drugs. It didn't seem as though we were seeing caveats in terms of, if you don't do this, you will face some sort of punishment. So it's not necessarily, would you say it's not necessarily the interaction, but the threat that was the problem here?
Yeah, you know, it's not the ask. It's the fact that these social media companies felt like they couldn't say no. And then I think a big 30,000-foot view on this is we're living in a much more divided time. You know, the drug war is a good example, right? Because we were all sort of on the same page back in the 80s about just say no. And now look at all the legalization that's taken place. And that shows, too, that the consensus opinion can change pretty quickly. So during COVID, when these companies were being told take down certain kinds of information, now a lot of that information is kind of more mainstream. So it's not the ask. You can ask politely, but it's the feeling of coercion, the bullying. If these companies don't feel like they can refuse that request, then that's where we get into some constitutional problems.
We could have a conversation about somebody who went to the White House who didn't pay attention to those anti-drug messages. That's another story for another day.
Always timely. Always timely.
Always is. Hey, Jessica, thanks for joining us. Again, just a good conversation to have because it caught a lot of people by surprise when you have a judge handing down a ruling on the 4th of July like this.
Yeah, well, I mean, set off some fireworks. There's never a dull moment.
Jessica Lugin, good to see you.
Thank you.
And the Final Five is back after this.
Say the joker to the thief.